Everyone may be seated.
Yes. Parents with the baby, I go, you know?
Yeah.
She said that if she didn't have to come in here, she doesn't want to come in. She doesn't want to hear
Okay.
from her.
Okay. Let the record reflect that the court is in session. The court is in session and calls number 23 CCC Aura 0225. Case is filed the state of Texas versus Bryce Smith. Let the record also reflect that Mr. Smith is present in court with his attorney Peter Dahl. Let the record reflect that the state is present with Assistant District Attorney Andrew Hubel, Attorney Sarah Staub, and Ms. Haley Simmons. State, are you ready?
It's ready.
Defense, are you ready?
Yes, sir.
At this time, ladies and gentlemen, I'm going to read to you the court's charge containing the law applicable to this case. Members of the jury, the defendant, Bryce Smith, stands charged by information with the offense of assault family violence. Alleged to have been committed in Jefferson County, Texas, on or about the 10th of February, 2023. To this charge, the defendant has entered a plea through the court of not guilty. I now give you the law that applies to this case. Our law provides that a person commits the offense of assault if the person intentionally, knowingly, or recklessly causes bodily injury to another. So that you may better understand the nature of the offense which the defendant is charged, I now define certain terms and words. The term bodily injury means physical pain, illness, or any impairment of physical condition. A person acts intentionally or knowingly, or a person acts intentionally or with intent with respect to a result of their conduct when it is their conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of their conduct when they are aware that the conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to the result of their conduct when they are aware of but consciously disregards a substantial or unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. The term family violence means an act by a member of the defendant's family or household against another member of the defendant's family or household that is intended to result in physical harm, bodily injury, assault. The term household means a unit composed of a person living together in the same dwelling without regard or whether they are related to each other. Family includes individuals related by consanguinity or affinity as determined under section 573.022 and 573.024 of the government code. Individuals who are former spouses of each other, individuals who are parents of the same child without regard to marriage, and a foster child or foster parent without regard to whether those individuals reside together. Therefore, if you believe from the evidence beyond a reasonable doubt that the defendant, Bryce Smith, did in Jefferson County, Texas, on or about the 10th day of February of 2023, did then and there intentionally, knowingly, or recklessly cause bodily injury to another, namely Eureka Edwards, a member of defendant's family or household, hereafter styled the complainant by pushing and scratching complainant about her body, you will find the defendant guilty. Unless you so find beyond a reasonable doubt, or if you have reasonable doubt thereof, you will find the defendant not guilty. General instructions. Number one, all persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant's guilt, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubts concerning the defendant's guilt. Number two, you have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. Number three, you cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in his presence. If any question develops during your deliberation, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Number four, questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Number five, any physical exhibits admitted in the evidence will be furnished to you by the bailiff upon your request. Number six, you must not consider facts that have not been introduced in the evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror, nor consider it yourself in arriving at a verdict. Number seven, you are the sole or you are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberation are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. And the last phase of the charge contains the verdict form. You'll notice two sections separated by order. The first section states, we, the jury, find the defendant not guilty as charged in the information of assault, family violence. If that is your verdict, then your foreperson will sign on the top line. And the bottom statement says, we, the jury, find the defendant guilty as charged in the information of assault, family violence. If that is your verdict, then your foreperson will sign on the bottom line. Does everyone understand? Okay. Now, state, are you ready? Defense, are you ready?
Yes, sir.
Okay, would either side, would 30 minutes for either side be enough?
Yes, sir. All right.
Okay, so I'll be keeping the time. Mr. Hubel, you have a right to open and close. Okay. So the state is waiving its right to open and reserving its right to close. Mr. Doyle?
Yes, sir.
And I'll be keeping the time.
Yes, sir. If it goes at 5 minutes.
Okay, I will.
This is, taking a little bit of time. Probably because. Okay. But if you look at it, it's pretty simple. Two witnesses then that saw it. If I'm on patrol officer, you testify in people, didn't see him. You can call to the scene after the defendant had left the scene and he didn't come back. Testified, the pictures, stuff like that. But ID guy came in and he didn't see anything that happened. There, they found after it. So you end up in a two witness case. And it's swearing. We're gonna do it. One of them says that he went to the house and he entered the house. She kicked him out. Before she kicked him out, he pushed him just or did something bad. He testified and went to the house and invited to go went to the house and entered and then things, whatever happened, happened. Confrontation, not between mother and son. It was between his aunt. And because she's not the mother, gave birth to him, gave him up. So is between the aunt and her nephew. He wasn't a resident. So the part of the information that was filed says, Eureka Edwards, a member of the defendant's family or household. Well, he's not a member of a household. So he's a member of the defendant's family who would be an heir, even assuming that the incident took place. In Jefferson County, just, I don't know everything, but I don't have any memory of a cousin or aunt being the victim of family assault in this county. So it may have happened and I don't know it, but I've been doing this for a while. And I don't remember them doing it, which gets into the argument of prosecution. But she testified that Eureka Everett testified that his mother, which came up for adoption, said, take the kid. I already had kids, didn't want another kid, I didn't want me having another kid, whatever reason she gave it up. And I would say that she's not. I think it's a more immediate requirement for the state to get these collective prosecution. I don't think they're doing that. And I got a point. Yeah, you got any money, not famous, they're not trying to prosecute somebody that was an elected official, there's nothing that's a newspaper here. But there would not be a reason to have a selective prosecution, and it's more likely that they don't do it. And they're doing it in this case because Eureka Edwards told the cops that she was his mother. So I can't, even without judging whether or not he actually scratched her, those are your two witnesses to the event. Everything else is circled. Now, I think that it is important that he gave up, or she, Miss Evans, gave up the kid because they alleged that she's a member, or he's a member, Bryce Smith is a member of Eureka Edwards' family. That's in this paragraph 3. Okay? And I think they're expanding the statute. They're going to get up here and tell you, yes, they're not, but they are expanding the statute. Or when there's a case law in Texas where the state has said that equitable adoption, which is what happened, equitable adoption is enough to support a murder conviction. Well, the defendant got 40 years. They're prosecuting, they're not prosecuting equitably. One guy they use it and when they more equitable or more easy or helps them, the other way they prosecute him for misdemeanor as opposed to murder. And I think that's, I don't agree with that. But they're saying, this report might get boring. Bear with me. They're saying that it depends upon the degree of consanguinity. Now, consanguinity is a legal concept, along with affinity. They're both legal concepts. And they're saying consanguinity includes, when you would go through the statute, an aunt who is the sister of a parent of the individual. Well, he's adopted. And he's adopted. And she gave him up. And if they had gone to the lawyer and the judge and gotten the adoption done, whenever it was, 3 days, he's 25, so it's 25 years ago. He'd have been terminated. Because can't have two. And the state's response is that they don't agree with me, obviously. But it's the procedural fact that if they'd had money and gone to a lawyer and hired the lawyer and done the adoption, she'd have been terminated. Then I don't think it would have matched. She'd still be his aunt. But I don't think that's what the statute was intended to do, the family violence statute. And if she's not a resident, or he's not a resident of her house, and she's not, as a strict interpretation of the statute, she's his aunt, and they don't do that, then there's a reason. Because in many cases, probably. But we would ask that you give consideration to that. If you think everything I told you is true, it's correct, then I can ask you to quit. They might ask you, it doesn't matter where, I don't know what they're say, but anyway. If they ask you to do the other, there's something more I can say. I mean, it's really not a very strong case for assault to start with, even if you assume that it's telling the truth. And it's not a strong case if they follow other cases. Now, they disagree, obviously. So let them explain it to you. But, this is a criminal case. It's not a felony, but it's Class A misdemeanor. If he gets convicted, he's going to have to live with that. And we would ask you that y'all return very quickly. So thank you for your time. Hope I didn't bore you. Good.
Okay,
See?
Mr. Hubel, you may proceed. I'm keeping the time.
Good afternoon, everyone. Thank you for your patience and attention this week. As Pete said, this is a Class A misdemeanor, but it's still very important that you all come here and do your duty and help the justice system be going. So what I told you during jury selection and during my opening statement were the elements the state had proven this case. And those are that in Jefferson County, Texas, on or about February 10th, 2023, the defendant, Bryce Smith, intentionally knowingly recklessly caused bodily injury to the complaining witness, Eureka Edwards, and the defendant, Bryce Smith, was a family member of Eureka Edwards at the time of the offense. Just to get a few of the elements out of the way quickly, Jefferson County and the offense date of February 10th, 2023, both Ms. Edwards and Mr. Smith, when he took the stand, placed the defendant, Bryce Edwards, at the 2940 South Street address in Beaumont, Texas, which is also in Jefferson County, on the evening of February 10th, 2023, when the offense took place. So, based on both the testimony of the complaining witness and the defendant in this case, there is no reasonable doubt as to the fact that this offense took place on February 10th, 2023 in Jefferson County, Texas. Now, as to the issue of whether or not Bryce Smith and Eureka Edwards are members of the same family, Mr. Doyle got into some issues about equitable adoption and all sorts of other issues. But for the purposes of the statute, adoptive parents, step parents, and birth parents are all family members. There's no requirement that the individual reside with an individual to be a family member, grandparents, aunts, uncles, cousins, there's no requirement that they reside together for them to be family. That just makes sense. And, now, Miss Edwards and the defense's witness, Miss Carol Smith, who is Bryce Smith's adopted mother, both agreed that Miss Edwards is Mr. Smith's birth mother. That means they're related by blood, and as the statute words it, and to Mr. Doyle's argument that equitable adoption somehow cuts off that blood relationship. Even if that were the case, that would still, as Mr. Doyle says in his closing statement, make Eureka Edwards' aunt, which still satisfies the statute, via affinity, because her husband is Carol Smith's sister, making Eureka Edwards' aunt. Now, as identifying the defendant, Miss Edwards did so in court. You all saw that, and the defendant himself places himself at the scene of the offense, where he occurred. So there's no real argument or reasonable doubt as to whether or not he was there, and really the jury in this case comes to the element of intentionally, knowingly, or recklessly causing bodily injury to Eureka Edwards. Now, bodily injury, as defined by the statute, requires only a showing of physical pain. There were some members of the jury who took issue with that. But Eureka Edwards' testimony did reflect that she did experience pain when Mr. Smith pushed her down and scratched her. Now the state did supply more than that in this case by via State's Exhibits 1 through 8, showing the physical injuries that Miss Edwards endured during the assault. In regards to the intent element, knowingly or recklessly or easily satisfied here, you can refer to your charge when looking at those elements. Knowingly simply requires that the defendant be aware that the conduct is reasonably certain to cause the result. And when you push someone, it makes sense that one would know that there's reasonable certainty that the person pushed could be injured by that pushing. Now, when Mr. Smith took the stand, he talked about some sort of conspiracy that he believed was cooked up against him regarding either custody or visitation of his daughter. But like we'd already seen in his testimony that when he tried to downplay and obfuscate his relationship or with her connection to Miss Edwards, that he is willing to he's willing to manipulate, stretch the truth whenever he's trying to get himself out of it.
Objection. I think that's a mischaracterization of the testimony of the defendant. He didn't.
That you talked about the issue with his daughter?
No, I'm talking about that you're presuming when
I mean,
he's born, he's given away. I don't think that's disputed. Well, I would object to it.
Okay, ladies and gentlemen, the jury, questions and comments of the attorneys did not constitute testimony and must not be considered as evidence. You must also disregard any statements of the attorneys that is inconsistent with the law contained in this charge. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. Mr. Hubel, you may proceed.
Thank you. So my point with all that is that you can, during your deliberation, you can only consider reasonable doubts. And the conspiracy theory that that the defendant's trying to posit with this testimony, when in view with the testimony of the complaining witness, the photographs of her injuries, and the fact that he himself places himself at their residence at the, on the date and at the time that this assault took place, makes consideration of that conspiracy theory unreasonable. And if a defendant they could use that kind of story to, whenever they're accused of assault, attempt to get their way out of it, then assault itself would be a meaningless offense, and the offense of assault family violence would continue to be the silent crime that some people were unwilling to assign a number to during jury selection because they were unaware of the exact amount of these crimes that were taking place in the community. So again, you're only to consider reasonable doubts in this case, and based on the testimony and evidence that the state has supplied, there should be no reasonable doubt in regards to the intentionally knowing or recklessly causing bodily injury to your evidence. So at this point, again, I want to thank you for your patience and attention this week. I'm going to ask that you take into account the evidence that was put forth to you at trial. Consider that evidence, look at the pictures, watch the body cam video, and determine the facts of this case, apply them to the law, and render a true verdict in this case. As Judge Holmes was showing you on the verdict form, this bottom part says we, the jury, find the defendant guilty as charged in the information of assault and violence. And should you render a true verdict guilty, the foreperson would sign, and I ask you to do so. Thank you all very much.
Okay, thank you, Mr. Hibble. Well, ladies and gentlemen of the jury, at this time, all the evidence, the court's charge, and the closing argument of counsel are before you. I'm going to hand to the bailiff the charge together with a verdict form. They will be left with you in the jury deliberation room. Once all members of the jury are present and assembled in the courtroom, the case is formally submitted to you and you may begin your deliberation. Please step down from the jury box and accompany the bailiff into the jury room. We stand in recess until the jury has reached a verdict. Jefferson County, okay, where is Smith?
I think she's gonna try to get that.
She just went up.
Okay,
She's still noted, right?
okay. Jefferson County Court at law number 2 is now in session. The court is in session and calls numbers calls number M329994. Cases style of State of Texas versus Jesus Geraldo Ibarra.
Yes, sir.
Ibarra. Okay, we have Mr. Ibarra, who is present in court with his attorney, Attorney Wright Kimler. State is present with Assistant District Attorney, Attorney Erica Porter, and Attorney Andrew Hubel. Before we get started, the court needs to put something on the record. Mr. Ibarra, hearing was set actually this morning at 11 o'clock. However, the court was informed that Mr. Ibarra was arrested on a warrant when he came into the courthouse.
Yes.
And we could not have the hearing at 11 o'clock because they had taken Mr. Ibarra to the Jefferson County Jail and he wasn't booked in. So we couldn't hold the hearing at that time. So the hearing was reset till 3 o'clock this afternoon. And on today's date of December 7th of 2023, after I finished eating lunch, I was approached by near the jury room by Harvey Ibarra, who I presume is the brother of Mr. Jesus Ibarra. Is that correct? Okay, so Mr. Harvey Ibarra approached the court, and I think from what I recall, said something about, I don't think I should be talking to you about this. I said, well, if it's anything pertaining to the case, any case that comes before me, I cannot talk to you about it. And then as I was leaving, he proceeded to say something to the effect that maybe it was wrong what they was doing to his brother or something to that nature. And so 10, 15 minutes later, I'm in my office signing files. He knocks on the door again. I'm talking about Mr. Harvey Ibarra. He comes in. He didn't come in the door, but he was in the doorway. And he said something to the effect about was it wrongful for him to do what he did, or was he going to get in trouble? So I informed him that I would because this was an ex parte or an attempted ex parte or an ex parte communication that I would inform the district attorney's office, and I would inform the defense attorney about this ex parte communication. So I'm informing both, and I called Miss Porter, and I think I left a message. I think she called back, and so when Miss Porter, I didn't get back with Miss Porter. I mentioned it to the prosecutors who were here, Attorney Sarah Staub, Attorney Andrew Hubel, and I also reported it to the law student that works with him as well, Haley Simmons. And I did talk to Mr. Kimler over the telephone. And while talking to Mr. Kimler, we had present in the room Haley Simmons, Andrew Hubel, and Sarah Staub, who's with the district attorney's office. And so at this time, if any party believe that there may be a conflict of interest or maybe an appearance of impropriety, then the court will recuse itself from participating in this hearing. And this, for the record, Mr. Ibarra is a deputy with the Jefferson County Sheriff's Office. And at sometimes he does come to court and act as a bailiff. I think he's on a rotation.
John, if I may, would the court be recusing itself from the entirety of the case or just for the bond reduction hearing?
Well, it was just for this hearing. I'm thinking because I mean, he didn't give me no details on the case, but or the case that's to come up. But I think he was attempting to
It would seem that the recusal would apply to the whole case then if the court is going to recuse itself. I mean, is that my understanding?
well, if there's a conflict of interest or if there's an appearance of impropriety, I mean, the court might have to recuse itself from hearing the entire case.
So if the court recuses itself from the hearing, it would be referred to County Court 3 for the bond reduction or the bond
No.
hearing?
We have to refer it to our administrative judge. And the administrative judge will assign or appoint a visiting judge to hear the matter.
So in that case, then his bond would remain the same. It wouldn't be increased. Is that correct for the pendency of the motion?
Well, it all depends. If
If the court is recusing itself from the.
well, I'm not doing a voluntary. I'm disclosing the information to the defense and to the state. And so if either party is asking that the judge recuse itself, then at that point, we have to send a request
Right.
to the administrative law judge.
That would preclude the court from.
Yes, from acting any further on the matter.
Well, we've asked the court recuse itself.
We're not, because based on my understanding, no facts were given to you through that brief conversation. And I'm not trying to stall or delay this proceeding. We're asking for the proceeding to go ahead and.
Well, we're,
Yeah, but I think if he's asking for a recuse, I don't think I can go far. Yeah.
I mean, what are the grounds for the recusal?
Well, I'm just saying this, I was approached by his, well, there could be an appearance of impropriety.
What is the appearance? I'm sorry, what is the appearance of?
There is a deputy sheriff who from time to time worked in this courtroom as well as some of the other courtrooms, who is related to this defendant as his brother, approached me about information concerning the case. I guess he wanted to talk to me about the case. And basically, I told him I couldn't talk to him about the case because any matters that come before me, I can't talk to him about it. And as I'm walking off, he said something about, well, it's wrong or something to that effect that what they were doing to him is wrong. So
Did he say anything about the facts or what?
I didn't let him go into that because I walked off and I told him I couldn't talk to him about the case.
Okay, well, the state does not request for you.
Okay, let's do this. We're going to take a recess. Okay, court is back in session in clause number M329-994, case of style of state of Texas versus Jesus Geraldo Ibarra. Mr. Ibarra is president, court district attorney, Attorney Brian Kimmer. State is present, assistant district attorney, Attorney Eric Reporter. The court took a recess. Mr. Kimmler requested that the court recuse itself. State objected. Now, Mr. Kimmler, your motion should be in writing, and it says should be filed as soon as practical after you know of the ground stating in the motion, the court inform you as to what occurred. And so the court is going to give you until tomorrow to file your motion, and it has to be in accordance with the rules of civil procedure. I think that in here it says the rule 18A civil procedures, where it has to be in writing, verified, etc. All right. So at this time, the court will be on recess. Tomorrow, you'll at least by tomorrow.
We filed tonight.
Okay, good. And so,
Okay, I have one conjecture. I am out tomorrow.
okay,
For medical reasons. Is there a hearing on the motion, or are you just going to sign off on it?
I need to, I think if the motion is filed, the court can do one or two things. The court can request that this court can sign off on it. The court can request that the administrative judge have a hearing.
Once it's filed, it's been a while since I've looked at this. I think once it's.
Yeah,
filed,
we can't
you don't-
do
it's not
anything.
discretionary, you have to-
Right.
It's been a while since.
Right. Okay, so this matter is over, and so the court will be in recess.
Thank you.
Okay.
Right. Remember the sample of the, you said, oh, shit. Oh, shit. Oh, it's a sample. We didn't know.
You have some letters for the jurors? Jefferson County Court at Law number 2 is back in session. Court is in session and calls number 23 CCCR 0225. The case is styled the state of Texas versus Bryce Smith. Let the record reflect that the attorney for the state, Attorney Andrew Hubel, Attorney Sarah Staub, and Attorney Eric Porter is present in the courtroom. Let the record reflect that the defendant, Mr. Bryce Smith, is present in the courtroom with his attorney, Attorney Peter Doyle. I have received a message from the jury that it has reached a verdict. Will a bailiff please bring the jury into the courtroom? Let the record reflect that the attorney for the state, the attorney for the defendant, and all members of the jury are present and seated in the courtroom. Foreperson, have you reached a verdict in this case?
We have your honor.
Is this verdict unanimous? That is, one that is agreed upon by all the jurors?
Yes, sir. Yes.
Okay. Would you please hand the verdict form to the bailiff to deliver to me for inspection? The whole George. Thank you. Foreperson, is the verdict a unanimous one that is agreed upon by all the members of the jury?
Yes, sir. Yes.
Okay, you may be seated. Mr. Smith, would you please stand? We, the jury, find the defendant not guilty as charged in the information of assault, family violence. Does anyone, any of the attorneys want the jury to be polled?
I agree.
No?
Yes, sir.
All right. Ladies and gentlemen of the jury, on behalf of the citizens here in Jefferson County, I'd like to thank you for your time and attention to this matter. This case could not be tried expeditiously and consistent with justice without citizens like you participating in this process. Your jury service at this time will be concluded. You would have to turn in the badges to the bailiff. Now, as I mentioned to the other members who were on the panel, I mentioned to them that anytime you're in the area, County Court at Law number 2, which is your courtroom, you can have a seat in that area called the peanut gallery. But as I mentioned earlier, you can't bring peanuts in here and eat because this is not the Texas Roadhouse. But you can come in here and County Court at Law number 2 and see what goes on in your courtroom. I tell people this all the time. I guess it's me personally. I like watching what goes on in court better than watching television. That's just my personal opinion, because there's some interesting things that are happening here in Jefferson County. Now, I do know that this is a conclusion to your jury service. If you need anything, our district clerk's office is right across the hall. They can give you what you need regarding this case. Now, the lawyers may want to talk to you. It's up to you if you would like to talk to them, or if you do not want to talk to them, that's your choice. As I mentioned earlier, I usually give everyone a handshake, but we still have some COVID in our community. So at this time, I'm gonna give everyone an air handshake. All right. And again, thank you for your time and attention. And may God bless and keep each and every one of you. Okay? So at this time, you're excused. Here you go. Not good. Everyone is excused?